we were doing claims mostly against the police where people were wrongly convicted or suffered, abuse or excessive force through arrest or otherwise. And we started to do both criminal, to continue to do criminal defense, but also to do this civil rights work, which was almost like being a prosecutor in a way of the police. But no one's going to jail. You're trying to get compensation for harm that's been caused to people through being falsely incarcerated or physically injured.
Host Melissa Rosenblum is one of only a few women certified by the Supreme Court of New Jersey as a criminal trial attorney. When you add kids, a booming law business, and a little black book full of subject matter experts, you've got the Mighty Merp podcast. And part 3 in this series. That's mightymerp.com.
So were you representing your criminal clients and then following through on civil rights claims for them?
Yeah.
Or
but some of it was that, and then there were just people who had their cases had been resolved and came to us afterwards. There's a lot of people who do criminal defense that don't cross over to do the civil work. A lot of criminal lawyers just strictly do criminal defense. So,
and that would be me.
Yeah. So if the criminal case ends and they, they were obviously mistreated, and they want to find someone to bring a claim, you have to find either the rare criminal practitioner who does it, or find an attorney that's doing civil law.
Right. So what makes a case a valid civil rights claim? Because as somebody who practices a criminal law, most of my clients believe they have civil rights claims and violations.
Right.
And although many of them are treated poorly, and there might be events during the process that are outrageous or, uncomfortable, immoral, all of that doesn't always rise to a civil rights claim, correct?
Right. Yeah, that's right. So essentially, when you're talking about a civil rights claim in the context of criminal law, because, employment discrimination is civil rights. There's denial of, freedom of speech can be a civil rights claim as well, but in other areas. But in the context of a criminal case, there's really sort of two sides to this. One is that you have been prosecuted and incarcerated based upon false information, or it's either false information or you've been denied a fair trial in the sense that evidence has been withheld, or witnesses or evidence has been manufactured, whether that's just somebody falsifying a record or coercing a false statement, or presenting a witness who's falsely testifying for whatever reason, whether they've made a deal with the state to give false evidence, or they've been coerced into it in some other way. So if you've been prosecuted and incarcerated, usually based upon false evidence or a lack of honest and credible evidence, then you have what's known as either a malicious prosecution claim, or in federal law, there's a statute that says that's section 1983, the Civil Code. It's 42 USC 1983, and that gives you a broad that covers a broad array of things, such that includes both malicious prosecution, that is prosecuting somebody without probable cause, or denial of a fair trial, and that evidence has been hidden or destroyed or falsified and you've not gotten fair process. So that's one side of the sort of the civil rights world, where you're essentially suing for your loss of liberty, costs of your defense, other things that you've suffered harm from being involved in the criminal process. The other side is when the police use excessive force. So if you are fleeing the police for some reason, and you're not particularly a danger to anyone, and they shoot you in the back to stop you, that would be excessive force, and you can bring a claim against the police for that. If you are beaten because you have given the police a hard time during your arrest, and you've angered someone, and they've taken it out on you by beating you and breaking your arm or knocking your teeth out or knocking you unconscious, whatever the case may be, and you have not really given a reason for that. That is, you've not caused a threat to the police or anyone else, but some police officer has decided that they're going to teach you a lesson, or they're going to make you pay for whatever aggravation you've caused, or they just don't like you, whether it's your race or what the police know about you or suspect about you. In those cases, you can sue the police officer as though you were, it's essentially a personal injury claim. Plus, because there's other sorts of, you can get punitive damages. There's very few kinds of claims in our system where you can get punitive damages, where the jury can impose a penalty on the defendant as a deterrent for doing this again. So those are the two sort of principal types of civil rights claims you have against police. As I said, there are other types of civil rights claims, but claims that arise from the criminal justice process usually involve wrongful conviction or incarceration and physical harm.
Now, is that how you got involved with the Innocence Project?
I actually, the case I worked on with the Innocence Project was a sort of a run-of-the-mill, I don't want to say, there's no really run-of-the-mill, but it was just a case that came to our office for someone who was claiming their innocence and was seeking a new trial or seeking redress from what they believed was a wrongful conviction. And it was a case I got involved in, and it had many sort of twists and turns. And the way I got involved with the Innocence Project was I had been working on this case essentially as a solo practitioner, and I was handling it pro bono. It was a case such as Chester Hollman, is a case I came to believe in the client's innocence, and these were humble people. They were not wealthy people.
I have to stop you because there are people that do not know what pro bono means.
Okay, so I basically did it for no fee. They originally hired me to do an appeal, and then once I got into the case and saw what was involved, and we developed some other evidence of Chester's actual innocence, I decided I had to do this case as a matter of conscience and not for fee. So totally a matter of conscience. So other than that, the initial appeal, the rest of the work was done, for free, basically. So, which
is what pro bono means. So I do need to clarify this.
Yes, right.
You were a private attorney trying to make money, and you said
correct. I was in business, and the great thing about being in business for yourself is you get to make these decisions. And this was a decision I felt that called for, I think it called for this kind of effort. So I got involved in the case and was doing mostly my own investigation and my own work. And then in the middle of the case, I represented Chester for close to 15 years. So I'd been working on the case for about 6 or 7 months, and 6 or 7 years, I should say. Sorry, and the Innocence Project hadn't even, at least the Pennsylvania Innocence Project, didn't exist when this case started. It was founded, I think, in 2010. And I knew the director. We had worked together
as a public defender.
And I called her up to congratulate her, and she said thanks, but she's like, we have no cases right now. You have anything we might be interested in? I said, do I ever? So we signed up with the Innocence Project, and they provided they provided investigators and lawyers to help us, and it became a collaboration essentially.
Okay, so we're talking about Chester, this case, which was an amazing case. My paralegal said that she watched the Netflix episode with you in it because she knew I was interviewing. And she said she bawled the whole time crying. So
I can't watch it and not cry myself.
So tell us about Chester. Tell us,
So Chester was a young man, and this is in 1991. He's a young man, grew up in suburban Wilmington, did not, grew up in a very kind of conventional suburban life. His parents both worked. They were churchgoers. He went to high school. He was in the band. He played football. He did a lot of different things. And when he graduated, he was going to community college. He gets a job working for an armored car company, if you could believe it, and was going to community college and had an ambition to go into law enforcement. I think he thought he might become an FBI agent, I think even. And he just moved to Philly because a lot of the work he was doing was in Philly. He was interested in getting out of the suburban life and a little more excitement. And gets stopped one night with a friend, a young woman. It was not his girlfriend, just a friend. Gets stopped because he's driving a car that matched the description of a getaway car that had just been used in a robbery shooting, turned out to be a murder, several blocks away. He gets stopped. He gets brought down to the homicide unit. Detectives were convinced he was the one involved, partly because of an incredibly outlandish coincidence, which I'll explain in a second. And they essentially coerce. He gives a statement that, basically a statement, explaining what he'd been doing. It's an innocent statement. It's an exculpatory statement. But his friend gets coerced into giving a false statement that they had been involved in this robbery and murder. And on the strength of that, and on the strength of another coerced statement they took from a guy who was on probation and out on bench warrants and a long criminal history and mental health history, he gave a corroborating statement. They charge Chester. He goes to trial and loses. Now, why was he stopped? Here's the incredible, outrageous coincidence that occurred. The crime happened in Center City. It was two just summer students at Penn were coming home late at night, like 1 a.m. from campus to go back to their apartment. And a car rolls up, guys get out, they jump the guy and his girlfriend, and they take his wallet and shoot him in the chest and kill him. They then jump back in a getaway car that's being driven by another woman, and they drive off. And it was a summer night. There's a lot of people out, even though it was 1 a.m. A cab driver witnesses this and follows the car. The car was a white Chevy Blazer. And he follows it several blocks and loses it, but he gets some of the tag, some of the license plate. Mm-hmm. He gets like five out of the 6 digits of the license plate. It was like letters, and then, or 4 out of the 5 digits, I think it was. 3 letters and a number. Or just the letters. I think it was just the letters. He calls it in. They send it out to police. So that vehicle, that white Chevy Blazer, had been rented from Enterprise. And as it happened, Enterprise had registered 3 identical white Chevy Blazers when they bought this. And they all were being rented in Philly. And because they were registered together, they had identical plates but consecutive numbers. Mm-hmm. Of course, the cab driver only got the letters and not the numbers. So wouldn't you know it, but Chester was in one of the 3 Chevy Blazers that had also been rented by his friend, and he was borrowing it, had the same 3 letters, and was stopped 5 minutes away from the crime, 5 minutes after the crime, like 6 blocks from the crime scene, in the car that was identified as a getaway. Essentially, the car was identified as a getaway car. Chester met the general description, though, of course, his clothing completely was different.
And what was the general, when you say he met the general description?
So he was a young African-American man. basically. He fit the general description. And there were two women in the getaway cars described by witnesses. And so he's in a car with one young woman and himself. His clothes don't match any of the clothing description given, but he met the general description. And of course, he's in this unique car, right? So the police were convinced they had caught the guy, even though there were supposed to be four people in the car. There were only two. His clothing didn't match. There was no gun. There was no proceeds. And so they arrest him and charge him based upon a coerced statement they took from the girl he was with. What's interesting
I'm gonna have to ask you, how often do coerced statements occur? Like, this is somebody that wasn't involved at all, knew nothing about this. How does I would say people are gonna say
common. It's not common, but it's more common than you would think. In other words, it's not common, but it happens. And this was an era when it probably happened more than it does maybe today. And it was not. There were many cases. So there's been many people exonerated from that era, and oftentimes it involved either a coerced confession from the person accused or witnesses. And so it's not. I'm not going to say it's common in the sense that it's not like one at. I'm not saying it's probably. I wouldn't even know how to say how many cases it was, but it's not common. I mean, and thank God it's not, because who wants to live in a country where, one out of every three cases is involved in a coerced statement. But what most people say, and people who are not involved in the criminal justice system at all, nobody would confess. Nobody would admit to something if they didn't do it. Of course, it's just not true. That's not true. And it's been shown over and over and over again that that's not true.
We hope you've enjoyed this episode. Stay tuned. There is more to come. Mighty Merp is available on iTunes, Spotify, and all your favorite apps and players. But the best way to experience the show is to visit mightymerp.com. That's mightymerp.com.